All right, I will call this hearing the Judiciary, Finance, and Civil Law Committee to order. Today is March 12th, 2024. We do have a quorum present. First item on the agenda is the minutes. Do I have a motion to approve the minutes of March 7th, 2024?
Chair Beckman, I reviewed them and I make that motion.
All right, Representative Johnson moves the minutes. Any discussion? All right, all those in favor, please say aye. Aye. Opposed? Motion prevails. The minutes are approved. We do have a full agenda today. All the testifiers who have signed up in advance have been provided with a time limit ahead of time, so they are aware of that. Signs are not permitted in the hearing room, and I'll just ask that the audience, there won't be any clapping or outbursts or anything like that. And then we will all be set. First item of business today is I got Representative Feist. House File 4457. Representative Feist, would you like to move House File 4457 be referred to the General Register?
Yes, Madam Chair, so moved.
All right, and then I understand you have a DE2. Would you like to move the DE2?
Yes, please.
All right. It's technical clarifications and getting the language in the shape the author would like. All those in favor of the DE2, please say aye.
Aye.
Aye. Opposed? Motion prevails. The amendment is adopted. Representative Feist, please tell us about your bill.
Yep, thank you. Thank you, committee. A fundamental aspect of our basic notion of justice is universal access to our judicial system, whether you are the richest or the poorest among us. Waiving court fees for indigent litigants dates back to the Magna Carta in 1215. And in the United States, as early as 1712. This practice is now institutionalized in every court in Minnesota and the United States. The purpose of this bill is to eliminate unnecessary work for civil legal services and volunteer attorneys, and for courts and judges. Under current law, a litigant must demonstrate indigency by filling out forms to show income eligibility for the fee waiver. The court then must make findings on the petition. Clients represented by Legal Aid and Volunteer Lawyers Network attorneys have already done that income analysis, and thus these clients are categorically eligible for a fee waiver. This bill would eliminate the redundant task of having Legal Aid and VLN lawyers fill in the forms, and they will save hundreds, if not thousands of hours for these civil legal services attorneys. It would allow these lawyers to attest that the client qualifies for the services and are thus categorically eligible for the fee waiver. It would also save the court and the judge time by eliminating the need to make findings in order to grant indigent status when civil legal attorneys have already done the income screen. Finally, I just want to note that this bill reflects recommendations of the Civil Justice Subcommittee of the Judicial Branches Committee on Equality and Justice. And I will turn it over to my testifier.
All right. Welcome to the committee. Please introduce yourself and go ahead.
Thank you. Thank you, Madam Chair, members of the committee. Ron Elwood with Legal Aid, and we just really appreciate Representative Feist bringing this forward. And I would only add that existing forms that legal services attorneys have to fill out when they've already done the income screen take very long to complete, and we think that by enacting this bill that it would allow our attorneys and pro bono attorneys to actually help more people because it would reduce unnecessary paperwork. So we appreciate your support. Happy to answer any questions.
All right. Are there any members of the public wishing to testify on this bill? All right. Not seeing any, we will move on to member discussion. Representative Johnson.
Chair Beckman, Representative Feist. Overall, I don't have much of a problem with this bill. I just have one thing I need clarification on. It's on line 1.3 to 1.4, where it was of the amendment.
Of the amendment. Okay. Gotcha.
No, this is the amendment.
Where it says presumed to meet the requirement. I'm just wondering what.
Are you sure about the line number?
It looks like it's line 1.13 to 1.14.
Okay.
My mistake.
We're with you now.
What happens if the individual is found out later does not meet the qualifications?
Representative Feist.
So the individuals that we're talking about would have already been screened by Legal Aid or by the Volunteer Lawyers Network, and they don't accept clientele unless they meet the same criteria that the courts require in order to have those fees waived.
Representative Johnson. All right. Any further discussion? All right, closing comments, Representative Feist.
This is a really good bill. It's a really smart bill. All of us hate paperwork. Please support my bill.
All right, Representative Feist renews her motion to send House File 4457 as amended to the General Register. All those in favor, please say aye.
Aye.
Aye. Opposed? Motion prevails. Thank you, Representative Feist. Next up, I have Representative Hassan. Came down in the elevator with me, so I knew you were here somewhere. So I will move House File 3692 be referred to the Commerce, Finance, and Policy Committee. And then I understand you also have an A1 amendment. Do you want to take care of that right away?
Yes, Madam Chair.
All right, I will move the A1 amendment. Chair Hassan, please tell us about your amendment.
The amendment is just a technical, this bill is a bill that has been worked on by many stakeholders, and it's feedback from all the stakeholders to just clean up the bill and make it look nicer, and maybe more people will agree with me.
Sounds good. All right, any discussion to the A1? All those in favor, please say aye.
Aye.
Aye. Opposed? Thank you for voting, Vice Chair Fraser. The A1 amendment is adopted. Chair Hassan, please tell us about your bill as amended.
Good morning, Chair Beckerfin and members of the committee. Today we have House File 3692, which is a bill to reform Minnesota's residential contract for deed laws to balance, to better balance the interest between investor, seller, and buyer of homes on a contract for deed, and to increase protections for residential contract for deed buyers. Contract for deed are an alternative method of buying a home. They are used by buyers, often low-income buyers, and buyers whose first language is not English, who cannot obtain traditional mortgage financing. Typically, these contracts involve an initial down payment, monthly installments, and a purchase price towards the purchase price, and a few years down the road, a large balloon payment. The buyer is typically responsible for paying for property tax, homeowners insurance, and maintenance and repairs of the property. This is a tool to help folks achieve the dream of home ownership when it's used the right way. However, we have been hearing terrible stories about families being ripped off and conned into contracts that aren't well thought out. Many of the articles written about the deceits and dangers of contract for deed describe a process that's flawed and meant to fail. Families are signing contracts that do not understand, coming up with large down payments, all in the hope of becoming homeowners. At the end of the day, well, that hope turns into a nightmare for many families in the immigrant communities, especially East African communities and the Latinx communities. Hefty down payments in the hundreds of thousands, monthly payments that are $5,000 to $10,000 a month, and a large unexpected balloon payment have left many families penniless and homeless, with an eviction on their record that they cannot even rent a place for their family. What does this bill do? It separates out it separates out the sales of investor-seller from mom-pop sales, preserves the status quo for contracts for deeds between individuals, and increase protections for buyers entering into a contract for deed with investor-seller. It requires critical and prominent disclosures. Investor-seller must disclose the amount and due date of any balloon payments, the price the seller paid to acquire the property, essential terms including the interest rate and whether the buyer is responsible for taxes, insurance, and maintenance, and amortization schedule. Investor-seller must know what you're getting into warning notice. Disclosures and notices must be in a language which the transaction was advertised and negotiated if other than English. Rights of buyers, requirement of investor sales. Buyers have the right to cancel within 10 days of receiving the required disclosures. Seller must provide an annual accounting to buyers. Requires 30-day pre-cancellation notice and 90-day cancellation period, allowing 120 days for buyer to come current. Investor seller must refund to buyers any down payment that exceeds more than 10% of the purchase price. If buyer defaults, an investor-seller cancels the contract within 48 months of the execution. And it also makes churning prohibited. I don't want to bore you with all the details of the bill, but I want to thank Ron Elwood and the legal aid for doing all the heavy lifting and assembling all the stakeholders. Supporters of the bill are Minnesota Attorneys General, Minnesota Department of Commerce, Minnesota Council of Latino Affairs, Minnesota Home Ownership Center, Second Resource Center, Habitat for Humanity, Neighborhood Development Alliance, Exodus Lending, Isuron, Jewish Community Action, and many more. The stakeholders that we consulted with, Minnesota Bar Association, the Real Property Section, Minnesota Realtors, Minnesota Land Title Association, Minnesota Mortgage Association, Minnesota Bankers Association, Minnesota Credit Union, and many more. With that, Chair Becker-Finn, I have a testifier, and we'll stand for questions.
All right. Welcome back. Please introduce yourself for the record and go ahead.
Thank you, Madam Chair. Members of the committee, again, Ron Elwood with Legal Aid. In the interest of time, I think I'll just be available for questions, but I do want to just, before we move to that, I really want to thank Kevin Dunleavy and the Minnesota Bar Association Real Property Section. The amendment that you see is long, but as Representative Hassan said, it's primarily technical, and what it does primarily is to ensure clear title. And that's what the amendment primarily does, and it's really based on so much work that we've done, many hours with the Bar Association. I also want to thank Paul Egger and the Minnesota Association of Realtors. We've been working with them as well. There's still, as you probably may hear, there's one tiny little issue that we're still working on, and we have, but we're very close to, I believe, working out that one little last kink. And I'm happy to stand for questions. I really appreciate it.
All right. Any members of the public wishing to testify on this bill? I will note there are a couple letters in your packets from the noted groups. Not seeing any, we'll move on to member discussion. Representative Scott.
Thank you, Chair Becker-Finn, and I just want to thank Mr. Elwood for working with all the stakeholders to reach resolution. I know it's still a work in progress, but I just wanted to say what a good partner you've been in working through these issues, and I hope that will continue. And we certainly don't want people being taken advantage of. They need to enter into these agreements with eyes wide open. Thank you.
Representative Finke.
Thank you, Chair Becker-Finn. My comments were the same. I wanted to thank Representative Hassan for showing us how this work is supposed to go. This is a very important problem, working together across all of the affected folks, bringing them together and solving the problem in a way that's meaningful. This is an important bill, and I'm excited to see it move.
All right. Closing comments, Chair Hassan.
Thank you, Chair Becker-Finn and members. I really want to thank all the stakeholders who have diligently worked with us. Ron did all the heavy lifting, but everybody came to the table. This is a real issue that's impacting many families, and I briefly want to share, I know time is very tight, but I briefly want to share a story that I read about one gentleman who has lost $300,000, and his family today are homeless, and he has lost everything, all his savings. He's a truck driver. All he wanted was just to purchase a home, and somebody took advantage of him, lost $300,000. He has an eviction on his record, and people are working with him, trying to remove that eviction on his record and hopefully house his family. But these numbers are real, and it's real people impacted by this issue. So please support. Thank you.
All right, I will renew my motion that House File 3692 as amended be referred to the Commerce, Finance, and Policy Committee. All those in favor, please say aye. Aye. Opposed? Motion prevails. Thank you. Representative Agbaje. I will move House File 4043 to be re-referred to the Public Safety, Finance, and Policy Committee. Let's see, we'll just remind folks that the reason the bill is in our committee has to do with the provisions in Section 2 about collecting people's addresses. So Representative Agbaje, please tell us about your bill.
Thank you so much, Madam Chair and committee members. So today I'm presenting House File 4043, which is also known as the Prison Gerrymandering Reform Bill. I'll just start with a brief overview of the bill before getting into the data issues, just so people have an idea of what it's about. Prison gerrymandering is an unfortunate flaw in our census collection system that over time has led to imbalances in the population count. When the census first began, the main concern was the relative population between states, as that data was used to determine representation in the United States House of Representatives. As the United States grew and as prisons grew, states started to use the census population data to determine local jurisdictions and their state-level representation. This meant that jurisdictions that contained prisons could count incarcerated persons as residents and attain a boost in representation based on imbalanced numbers without the participation of the incarcerated people in the community of the prison. It meant that the home communities where prisoners had come from would lose their portion of political power in the state based on population. While the Census Bureau has not decided yet to act on this, states are using their power to reallocate the data that comes from the census every 10 years to ensure a more accurate count. This bill lays out that for the 2030 census and beyond, the Minnesota Department of Corrections and the Legislative Coordinating Commission will begin to reallocate incarcerated persons in state and federal prisons to the census blocks where they came from, rather than to the jurisdiction of the prison. In order to protect the privacy of incarcerated persons, the DOC will create a unique identifier for each person that has their last known address and along with other data and send that to the LCC. The LCC will then use that data to reallocate incarcerated persons to their original census block for a proper count. And to smooth out this process, the LCC and the DOC will develop a common form that standardizes the format of the address data. The LCC will also geocode the data and accept addresses that have a rooftop or a range interpolated accuracy, and addresses that have an accuracy of a geometric center or approximate would not be used, and then those incarcerated persons would be counted at the state level. The data collected from the incarcerated persons will be noted as private data and cannot be disseminated except as required by state or federal law. Additionally, prisoners participating in the Safe at Home program would not need to provide an address. So members, I ask for your support on this bill as it continues through the legislative process. And by starting now, we can prepare for a 2030 census and ensure that Minnesotans are being counted and represented fairly. And with that, if there are any testifiers, and then I can also take questions.
Yep, and I do know we have someone from DOC available for questions if needed. Otherwise, I don't have anyone else signed up. Are there any other members of the public wishing to testify on this bill? All right, not seeing any, we will move on to member discussion. Representative Scott.
Oh, that's the lone voice here. Representative Agbaje, I'm just wondering how or if, when a prisoner gives their last known address, how will that be verified? Or will it be verified?
Representative Agbaje.
Thank you, Madam Chair. Thank you, Representative Scott, for the question. So just like the census itself, knowing where people live, it's a self-reporting process. And so with the data that the DOC currently has, a lot of that comes from the court system. So that's also sort of based on kind of what the court knows about that person. Then for the data that for incarcerated persons that will fill out the form, it will be based on kind of their last known recollection. And if that address, based on the geocoding system, can be verified to a specific location, then it will be used.
Representative Scott.
That's all.
Any further discussion to the bill? Closing comments, Representative Agbaje.
Thank you, Madam Chair. Thank you, members. I appreciate your support moving it to the next committee.
All right, I will renew my motion that House File 4043 be referred to the Public Safety, Finance, and Policy Committee. All those in favor, please say aye. 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 Opposed? No. Motion prevails. Thank you, Representative Agbaje. Representative Freiberg. I will move that House File 1930 be referred to the Commerce, Finance, and Policy Committee. And then I understand we have an A1, 14-1 amendment. Representative Freiberg, would you like us to take care of that amendment right now?
Yes, please.
All right, I will move the 14-1 amendment to House File 1930. Representative Freiberg, if you tell us briefly what that amendment does.
Sure. The amendment clarifies the language around mental health consultants and makes some changes requested by different provider groups, such as the Minnesota Pharmacy Alliance and the Long-Term Care Initiative.
All right, any discussion to the 14-1 amendment? Representative Niska.
Thank you, Madam Chair, and Representative Freiberg. I was wondering about the deletion of some criminal provisions related to providing false statements, and was curious as to the rationale for the deletion of the criminal provisions on, I think it's lines, on page 10, lines 18, 19, 20, 25, 26, and 27. Just hoping you could provide some understanding as to why we would take those criminal provisions out.
Representative Freiberg.
Thank you, Representative Niska. Yeah, those provisions are very narrowly focused on providers who mislead patients about their willingness to qualify an individual for medical aid in dying. So it's not about providers who mislead people into thinking they qualify for MAID when they don't. The fear is that a provider might tell a patient who qualifies, oh yeah, I can get you medical aid in dying medication, when they in fact have no intention of doing so. Provider groups asked that this be handled consistently with their existing disciplinary regulations. So like if you look at the language on line 10.17, it says that this only applies to deceptive practices relating to the provider's willingness to qualify an individual or to provide a prescription to a qualified individual for medical aid in dying medication.
Representative Niska.
Yes, one follow-up. So I understand the discussion about ethical or disciplinary procedures. Are there criminal penalties currently about misleading someone in that way more broadly, or are we sort of pulling back from having any sort of potential criminal liability in that context? That's not clear to me from just looking at the language.
Representative Freiberg.
Yes, thank you, Representative. Thank you, Chair Becker-Finn. Thank you, Representative Niska. If you look to line 16.4 of the bill, it spells out all the offenses and penalties. So, and I understand that's relevant to the jurisdiction of this committee too. So we'll be discussing those, I assume, in more detail. But things like coercion are listed specifically as a felony.
Representative Niska.
That's all I have for now. Thanks.
All right. Any more discussion to the 14-1 amendment? Not seeing any. All those in favor, please say aye. Aye. Opposed? Motion prevails. Representative Freiberg, please tell us about your bill as amended.
Thank you, Madam Chair. The Minnesota End-of-Life Options Act is modeled after an Oregon law which has been in effect since 1997. 10 states and the District of Columbia have enacted similar laws since that time. Now, I know we're focusing on provisions germane to the Judiciary Committee, but just so you have a general sense for the bill, the main criteria for medical aid in dying have remained unchanged since I first introduced the bill in 2015. To qualify, a person has to be an adult, meaning they're 18 or over. They have to be diagnosed with a terminal illness with a prognosis of 6 months or less to live. They have to have the mental capacity to make healthcare decisions and provide informed consent, so people with dementia don't qualify. They have to have the ability to self-administer the medication. Injections and infusions are prohibited. Additionally, 2 providers must evaluate the patient and agree that they meet the qualifications. So both providers have to confirm that the patient is acting of their own volition and not subject to coercion. They have to inform the patient of all feasible end-of-life care options, including hospice and symptom management. They have to provide a referral to hospice if indicated, and they have to offer the patient the option to rescind the request at any time. Now, speaking to the provisions germane to this committee, Section 8 on page 12 states that providers acting in good faith and following the law won't be penalized. Subdivision 5 on page 14 protects the privacy of patient and provider information that is submitted to the Department of Health for purposes of data collection or compliance oversight. Section 10 on page 14 protects individuals' freedom to choose medical aid in dying without impact on wills or other contracts. Section 13 on page 16 establishes penalties for coercion that align with current Minnesota Statute 609.27. This is what I was referencing before when I was discussing this with Representative Niska. So coercion includes intentionally altering or falsifying a request for medical aid in dying medication for another individual, intentionally destroying or concealing an individual's rescission of a request for medical aid in dying, things along those lines. And just to be clear, in the states that allow for medical aid in dying, there is no verifiable evidence of abuse. I'm not sure if it's in your packets. I know it was in the last committee, though. There was a letter from Disability Rights Oregon that indicated no reports of abuse related to the law that they have for medical aid in dying. So that's just a brief overview of the bill. Happy to stand for questions or turn it over to testifiers, whichever you prefer.
We can go, we have quite a few testifiers, so I think it'd be great if we could get moving on that. All right, and as I mentioned, people have signed up ahead of time. They know how much time they have, so hopefully they timed themselves in preparation. First up, I have Lori Thompson, and then I have Dr. Terry Knowles. And when I tell you that you are on deck, if you could come and sit up at the table just to move things along, that would be great. So Lori Thompson. All right. We'll move on then to Dr. Terry Knowles. And then I've got Wendy Brown on deck. All right, please introduce yourself for the record and then proceed.
Yeah, I'm Dr. Terry Knowles, a family physician from New Ulm, Minnesota. If this bill passes without a conscience clause, it will have several devastating effects for small-town hospitals and clinics. If there is no immunity from participating in physician-assisted suicide, there will be physicians and advanced care providers who will be forced out of medicine. We cannot afford that in our rural communities. It's already very difficult to find doctors who are willing to take frequent call and heavy patient loads. This would affect hospitalists who do inpatient care along with all primary care providers. If our oncologist, who oftentimes becomes the primary care provider for our cancer patients, refuses to participate and has no immunity, that would absolutely devastate our cancer care centers who provide care to all of southern Minnesota. The loss of revenue for primary care and oncology cannot be made up elsewhere. This bill has the potential to force the closure of many rural hospitals and clinics. I beg of you to see the implications to my patients and my partners at the New Ulm Medical Center and in many rural areas. Thank you.
All right, thank you for your testimony. Next up, I have Wendy Brown, and then I have Dr. Bergeson on deck. Please introduce yourself and proceed.
Good morning. My name is Wendy Brown, and I am here today in support of HF 1930, the Minnesota End-of-Life Options Act. I am both a death doula and a founding member of the Minnesota Death Collaborative. I'm speaking only for myself. I'd like to speak briefly to two provisions of the bill. The decision to choose medical aid in dying has multiple steps that involve primarily physicians, but also the family and other members of the healthcare team. However, this decision can only be made by the loved one who is dying. Like all treatment options, it is discussed over time and in the context of all efforts to relieve suffering and in the context of the individual's values. My role as a doula is to steward people through their final stages of life, bringing peace, meaning, and even beauty to this life event. Having been through the end-of-life process with a number of clients and my own mother, I, as a doula, work side by side with a hospice team. We engage families and loved ones, encouraging conversations and focus on meeting the dying individual's specific wishes around death, gracefully folding in their values and legacies. I felt compelled to share my experience as your committee considers Section 8, penalties for coercion. I absolutely support criminal penalties for coercion, but I also want to reinforce that the hospice setting holds no room for coercion. Doulas work with patients in creating rituals and personalizations within this safe and thoughtful space. We continue to be an extra set of eyes as we advocate for our client. Hospice staff and doulas are often present with the patient and family members at the time the medication is taken, companions on the patient's journey. The patient-centered advocacy of hospice and doulas creates a space of trust for the patient and protects against coercion. I would also like to speak to the importance of Section 8, which clarifies that individuals are at the bedside, doctors, doulas, social workers, nurses, pharmacists, or family members can make sure the medication is properly mixed, handled, and disposed of safely. We serve at the last check to ensure the patient is ready and able to ingest and administer the medication and acting on their own volition.
I'll need you to wrap up.
I urge you to support the Minnesota End-of-Life Options Act as it will remove pain and offer peace, safety, and love to those who choose this path. Thank you.
Thank you. Next up, I have Dr. Stephen Bergeson, and then I have Rosie Gaston on deck. Please introduce yourself and proceed.
Thank you, Chair Becker-Finn and committee members. I'm Dr. Stephen C. Bergeson, and I've had the privilege of caring for hundreds of patients at the end of life during my 39 years as a family doctor in Shoreview, Minnesota. I currently care for patients as a volunteer physician in clinics for the underserved. I'm requesting this committee oppose H.F. 1930. This bill forces me, under penalty of law, to offer assisted suicide as a treatment option to all my patients, which I believe is incompatible with the physician's role as a healer. And 80% of the delegates at the fall AMA meeting agreed with me. They ruled the practice is incompatible with the physician's role as a healer. The penalties I will face for not offering this option to all my patients who have 6 months or less to live are gross misdemeanors and disciplinary action by my licensing board. Yet the bill offers extensive protections for the small proportion of clinicians who will help patients end their lives. To be clear, the bill allows me to choose whether or not to write prescriptions. But this bill breaks new ground by specifying that I, the trusted physician, during the informed consent process, must inform my patient that I can prescribe medications with the intent to kill them, whether they are asking for it or not, as an option. Requiring me to include assisted suicide as an equal option to treatments that can ease pain and maintain quality of life forces me to participate in the process and act against my conscience. This bill needs an expanded conscience clause so the covenants to save life and not to kill, which my colleagues and I have made to society and to each other, and our faith commitments, can be preserved. Please oppose H.F. 1930. Thank you.
All right, thank you for your testimony. Next up, I have Rosie Gaston, and then I have Kathy Blazer on deck. And I'll have to ask the person sitting next to Representative Freiberg, I can't have you whispering while people are testifying. Thank you. Please introduce yourself and go ahead.
Good morning. My name is Rosie Gaston, and I am a hospice clinical social worker here in the Twin Cities. I spent hundreds of hours of my life researching, writing, and educating about medical aid in dying. I've also spent thousands of hours of my life caring for the terminally ill members of our community. I, without hesitation, support the End of Life Options Act. As I read over the sections for today's hearing, I felt a sense of relief come over me as I processed Section 8. To me, this entire bill exemplifies choice, and this section protects that for clinicians, whether that be the choice not to participate or to be on the front lines like I will be. Hospice clinicians are end-of-life experts, and we need to be at the heart of this, not only to provide guidance, support, and symptom management, but to be an extra layer of protection against coercion. Our patients are already asking us about this. If a legal option, patients will want a plan and process made with their hospice team. They likely will want our support on the day that they choose to bring about a peaceful death, as in most cases, they have come to trust and rely on us. While not mandated, professionals must be allowed to prepare the medication, as this enhances safe practices and removes the burden from the patient. We should be in the room when the patient self-administers the medication, and not just for education and support, but to hold vigil for the people who love that person the most. For many hospice clinicians, this is our gift to the world. To make something that could be traumatic be something intimate, peaceful, and meaningful. And we need to be able to share our gift without fear of losing our license or our jobs. And hospice agencies need to create policies that allow us to serve in this space without fear of litigation. Thank you sincerely for providing that in Section 8. There are many more hospice, medical, and mental health clinicians that support this compassionate end-of-life choice. I started a petition last week, and in 1 week, I have 90 signatures of licensed Minnesota clinicians that support this option. So on behalf of myself, my 90 colleagues, my past patients, my future patients, I ask of you, I beg of you to please move this forward. Thank you.
Thank you for your testimony. Next up, I have Kathy Blazer, and then I have Dr. Thaddeus Mason Pope on deck. Please introduce yourself and proceed with your testimony.
Thank you, Madam Chair and members. I am Kathy Blazer, Co-Executive Director of Minnesota Citizens Concerned for Life. This bill would lead to a different standard of care for those with disabilities and those without. Physically healthy and able-bodied suicidal patients would be offered suicide prevention, while those disabled or terminally ill suicidal patients would be offered the drugs needed to end their lives. This double standard likely conflicts with the Americans with Disabilities Act. A current federal lawsuit alleges that California's assisted suicide law discriminates against people with disabilities, violating equal protection and due process in the 14th Amendment and the anti-discrimination provisions in the ADA and the Rehabilitation Act, because it steers people with terminal disabilities away from necessary mental health care, medical care, and disability supports, and towards death by suicide under the guise of mercy and dignity in dying, subtly encouraging them to seek assisted suicide to reduce the perceived burden on their families and the healthcare system. HF 1930 effectively legislates a double standard of suicide prevention and suicide assistance based on an unreliable, mutable, and difficult to predict standard of 6 months or less to live. Instead of offering appropriate treatments and supports required to live well, this bill would offer disabled and terminally ill patients the easier and less costly option of simply being done with such difficult and seemingly burdensome living. There are no safeguards that can protect us from these dangers. Every state that has passed these laws has quickly moved to expand access and remove supposed safeguards. It is disingenuous to pretend these expansions and resultant abuses do not happen. It is very difficult to quantify abuses when the supposed safeguards are consistently removed under the guise of expanded access. I ask you to wrap up. I ask you to protect our most vulnerable patients and vote against HF 1930. Thank you.
Thank you for your testimony. Next up, I have Dr. Thaddeus Mason Pope, and then I have John Milkey on deck. Please introduce yourself and proceed.
Good morning, Chair Becker-Finn, members of the committee. My name is Thaddeus Pope. I'm a law professor at Mitchell-Hamlin School of Law in St. Paul. I've published over 300 articles and 2 books on end-of-life decision-making, and I speak in favor of the bill in my personal capacity. And I'm only going to address HF 1930 sections 8, 10, and 13 on immunities, penalties, and the effect on wills and contracts. These sections are common in the MAID statutes of 10 other states. They're common in the MAID bills now being considered in 20 other states in March right now. And furthermore, these 3 sections parallel sections in the decades-old Minnesota Statute 145C. So that 1993 statute addresses healthcare decisions and advanced directives. And like HF 1930, it addresses actions taken by healthcare providers that end patients' lives at their request, right? It's pointless to authorize a healthcare option if providers are too scared to participate in it. So like HF 1930, 145C grants the same immunities, right? So providers feel comfortable following patient wishes. And then finally, HF 1930 authorizes a range of criminal and civil penalties. That's completely appropriate. It's important to note that there has never been a criminal prosecution or a medical malpractice lawsuit concerning MAID in more than 15,000 cases over the past 26 years. Thank you.
Thank you for your testimony. I have John Milkey, and then the last person signed up ahead of time is Dr. Stuart Hansen on deck. Please introduce yourself and proceed.
Chair Becker-Finn and committee members, I'm John Milkey, an internist and geriatrician, speaking on my own behalf. I'm the Chief Medical Officer of Pres Homes and past president of the Minnesota Medical Directors Association. I'm speaking in opposition to this law because it forces me to violate my own personal ethical principles. I share this concern with many of my colleagues, of which you've heard from just earlier. This law sets a new standard of care, and that's certainly what laws do. They tell us how to practice medicine when enacted. The law holds us accountable for providing full informed consent to our dying patients, including medical aid in dying. If we do not provide informed consent in keeping with the demands of the law, we are practicing what would be termed deceptive medicine and are liable to be charged, if I read the law properly, gross misdemeanor, and reported to our board with possible restrictions and revocation of our license. I am personally ethically and morally opposed to even mentioning medical aid in dying to my patients. It's a violation of everything I stand for as a physician and as a human being. Many of my colleagues feel the same way, but we are willing to suffer the consequences of following our conscience in opposition to the terms of this law. So my question of the committee is the state of Minnesota prepared to punish and lose many competent and ethical medical providers who cannot comply with the informed consent demands of this law? If this scenario is not intended by the author of the law, and I've misread it, I recommend very clear language be added to the law that allows providers to operate on a conscientious objection basis and not bring up this informed consent for medical aid in dying as part of our patient care. Thank you very much.
Yep, thank you for your testimony. Last, I have Dr. Stuart Hansen. Please introduce yourself and proceed.
Thank you, Madam Chair, members of the committee. My name is Stuart Hansen. I am a pulmonary, or have been I am a retired pulmonary and critical care specialist. That practiced here in the Twin Cities for 41 years. I've had over 4,000 conversations with people and their families about end-of-life planning and end-of-life issues. I've written 2 books. One is called Do No Harm. It's a personal memoir. The other is titled A Senior's Guide for Living Well and Dying Well, and the subtitle is Conversations That Matter. The physician's role is to cure when we can, and to care always, and also to relieve pain when suffering is present and cure is not possible. And that's what we're talking about here, is the relieving suffering of people who are dying. So the end-of-life options would give providers one more option to relieve suffering in the terminal ill patients. Section 8 gives protections and actions, and I'm not a lawyer, but the way I read it, it protects providers for prescribing. It requires no providers to participate, and providers are protected from reprisals if they do participate. And lastly, the terminally ill patient is protected if they choose medical aid in dying. So I urge the committee to pass the End of Options Act, House File 1930. And I'd be glad to answer any questions if there are some.
Right, thank you for your testimony. With that, we'll move on to member discussion. Due to the nature of this issue and there being multiple stops, the public testifiers were as arranged ahead of time. So we'll move on to member discussion. Representative Johnson.
Chair Becker Finn, Representative Freiberg. Just so you know, I'm deeply opposed to this bill. My life is precious. Besides Representative Grossel and myself, I don't think anybody on this committee has seen death more than the 2 of us. And it's not fun to be dealing with. Now, in the medical world right now, across this country, there's about 250,000 deaths per year because of mistakes and errors. I'm glad that it requires 2 doctors in this bill to look at this issue for a patient that's considering this. But I do still have concerns because there's so many errors that cause death already in the medical field. I was doing some quick searching because one of the testifiers brought up the fact that they're concerned for lack of doctors. Minnesota is already in the bottom third as for the number of doctors per patient. We had 309 roughly patients per 100, or 309 doctors for, let's see, what was that? The number of doctors per patient is high compared to the rest of the country. And looking up the other 10 states that have it, all but Vermont is in that same shape. So I'm concerned that we are going to have an issue having doctors and getting help for those who need to see a doctor. I tried to go in fact, yesterday I tried to go in and get some lab work done. And in the past, I'd just be able to walk in, no problem, get it taken care of. I got to wait till next week to get the lab work done because they're short-staffed. Is this going to make it worse? With all the numbers we're seeing, the states that have this, they're short doctors. And then the other issue I have is in this bill, there's no exemption if a doctor's beliefs is against this. They have no option. I think you need to look at giving away for those who have a conscientious objective against this, not to be part of it, but the way this bill is written, they have no option. So with that, I'm going to request a roll call on this and ask members to vote.
Representative Freiberg.
Thank you for the comments, Representative Johnson. Thank you, Madam Chair, for recognizing me. So I agree with you, Representative Johnson, that the shortage of doctors and other medical providers is a critical issue, but I just don't see how this bill is going to exacerbate that issue. And I don't understand the testimony, really. I'm glad you brought up the issue of the conscience clause and so forth, because I don't really understand the testimony stating that it's not in the bill. If you look at the bill, I'll just point to 3 sections real quickly. On line 10.7 of the bill, it's right there in bold-faced letters. It says there's no duty to provide medical aid in dying. Just a little further down, 10.11, a provider may choose whether or not to practice medical aid in dying. If you go to 11.8, it says that a healthcare facility may prohibit providers or pharmacists from qualifying individuals or prescribing or dispensing medical aid in dying medication while performing duties for the facility. And then there was also reference to a supposed lack of immunity, but that's is also clearly in the bill. If you go to, I have the wrong page written. Just 1 second here. Sorry, page 12, line 24. So the heading says that no provider or healthcare facility shall subject a provider, pharmacist, or licensed mental health consultant to discharge or so forth, or provide any penalty for, and then you skip down to number 3, it says choosing not to practice or participate in medical aid in dying. So there are safeguards in place to ensure that no provider is required to participate in medical aid in dying when it is against their beliefs to do so.
Thank you. Representative Feist.
Thank you, Madam Chair. That is a good, I have a good follow-up comment. I was going to point to all those sections and just point that out. I get really frustrated when we talk about healthcare bills that there are people who just have these conclusory statements that if we do something proactive or different at all on healthcare policy, that we'll lose doctors, our healthcare system will get worse. And our healthcare system is really bad, as Representative Johnson pointed out. And we do need to make change, and we do need to be proactive, and we do need to find ways to honor our humanity in our healthcare system. I have really bad asthma, and I don't feel like our healthcare system cares. I don't feel like it's about care. So anyway, that's just a philosophical comment I wanted to make, is that I'm just really sick of people saying the sky is falling if we do anything proactively, if we change anything. And I'm glad you pointed out those provisions in the bill. Thank you.
Representative Niska.
Thank you, Madam Chair, and Representative Freiberg. I wanted to turn your attention to the words right after the words you highlighted on line 10.7. So the bold words say no duty to provide medical aid in dying, but then the words after that are kind of concerning to me, and I think they're what some of the testifiers were asking or were talking about. So it says, a provider must provide sufficient information to an individual with terminal disease regarding available options, the alternatives, the foreseeable risks and benefits of each, so that the individual is able to make informed decisions regarding the individual's end-of-life health care. And my question for you first is whether state-sanctioned suicide is one of the available options that a provider must provide under that language.
Representative Freiberg.
Thank you, Madam Chair. Thank you, Representative Niska. No, as I cited before, to 3 sections, a provider is under no obligation to provide medical aid in dying. I mean, I understand where you're going with your question. I mean, the intent is that before getting informed consent for medical aid in dying, clinicians must present all options, including hospice. If there's some language, that we can continue to work on, I'm certainly open to hearing your suggestions, but as I said, there is no requirement for any provider to provide medical aid in dying.
Representative Niska.
Thank you, Madam Chair, and Representative Freiberg. I think you're not quite answering the question, which is, I understand they're not required to provide the drugs or participate in prescribing the drugs. My question is the sufficient information regarding available options that they're required to provide, does that include telling them that state-sanctioned suicide is one of the options? And if a provider in that circumstance doesn't provide that or doesn't inform them about that as an option, are they violating this language in starting on 10.7?
Representative Freiberg.
Yes, we want our providers to notify people of all options. As I said, though, there is no obligation for them to provide the medication.
Yeah, and I think as I'm looking at it too, I think if you go to sub C too, it says if the provider is unable or unwilling to provide related information or services, there's a clause there that is applicable as well. Follow-up, Representative Niska?
Thank you, Chair Becker-Finn and Representative Freiberg. We had a lot of discussion about the medical standard of care and about coercion and undue influence. What is coercion or undue influence in this context?
Representative Freiberg.
If you give me 1 second, I'll just find the exact definition of it. So, yes, thank you, Madam Chair. Thank you, Representative Niska. If you look to line 16.4 of the bill, these are sort of the general things that are considered coercion, intentionally altering or falsifying a request for medical aid in dying. Number 3, I think, is kind of the most common thing that we'd think of it, and it uses the word coercion, compels another individual to request medical aid in dying medication through the use of coercion, undue influence, harassment, duress, compulsion, or other enticement. We had some discussion about this in the Public Safety Committee as well. I think it's important to include these protections in the bill. However, the data do show that from Oregon, which has had this in effect for 25 years, that there's no documented instance of coercion occurring. But I do think having this provision in here and making it the strongest possible penalty, a felony, does provide assurance that there won't be any.
Representative Niska.
Thank you, Chair Becker-Finn. I appreciate you pointing out that in Oregon, any witness who might be able to, prove a case of coercion is no longer, able to provide that testimony. That doesn't really solve the problem, and frankly, I think that the language in 10.7, if you actually think about the circumstance and what you're telling providers they have to do, is the definition of coercion and undue influence. We're telling every provider in Minnesota that every time, every patient that they see, that they decide has a terminal illness, they must provide as one of the menu of options as they're discussing the cost to their family of all of these different providers. One of the options they have to provide to them is that the state of Minnesota has now sanctioned them to check out, has now sanctioned them to commit suicide. And that is, in many circumstances, first of all, it's coercive to the providers, and I think you've heard from them that it is coercive, and I appreciate your honesty that they are going to be required to tell their terminally ill patients that is one of the things that they can and maybe should do in one of the most difficult, impressionable times, most traumatic times in somebody's life. That's what they're going to be required to tell them. And not only is that, I think, coercion of our medical professionals. I don't see how we can distinguish between that coercion, harassment, or an undue influence and what we're trying to criminalize. Of course, if we, as a state, say that every provider has to engage in that level of coercion and undue influence, we're never going to find a case of coercion and undue influence. We've already said that this is the baseline level of coercion and undue influence that's required by every single provider every single time someone has a terminal illness that a medical professional thinks they only have 6 months to live. As I'm sure you're aware, those predictions are often false or don't turn out. Medical professionals, in their reasonable judgment, often think that patients only have 6 months or less to live, and they survive well past that. This is not only involving the state of Minnesota in the machinery of death, it's requiring our healers to also participate in the machinery of death. It's wrong. I urge members to vote no.
Representative Grossel.
Madam Chair and committee, Representative Freiberg, just following up on Representative Niska's line there, you look at the words that you have in here, must and may and all of that and shall, all those have meaning. All those have meaning. Chair Becker-Finn pointed out that, there's a part in there that a provider, if a provider is in section C, I'm looking at line 10, 12. If a provider is unable or unwilling to fulfill the individual's request for medical aid in dying, medication, or to provide related information or services, the provider must, upon request. So the doctors who were up here testifying earlier, they're looking at all this language, and there is that must in there, that they must be a part of this in some way, shape, or form. And that is what they're looking for from you as the author, or from the state, is that if they don't want to participate in this, that help them to have some peace in their minds and hearts, just like you want to help the other folks with some peace in their minds and hearts if they want to go that way. Help them to be able to, with a clear conscience and clear mind, to not be a part of this chain. We sit here on these committees and we go, we make these decisions, make these laws, but we have to make sure that we don't force people to do things that they don't want to do. And I'm very saddened by what has been going on in our state legislature here as of late, turning Minnesota into a destination state for death or mutilation. That is not the kind of reputation you want.
Representative Grossel, please stick to the bill.
I am, Madam Chair. I'm sticking to exactly to what's going on here. And it's like I said, this is coming, these are coming as words of wisdom from an elder that I've been around long enough now to know that there's some things that you just don't do. Human life is valuable. Human life is not something to be just extinguished. And I think we are going way beyond where we should be as a state legislature when we start making it okay to devalue human life to the point that we just willingly extinguish it at wherever time we see fit. Folks, we're not God. And that's where I'll leave it.
Representative Finke.
Thank you, Madam Chair. And Representative Freiberg. I just wanted to point out a couple of thoughts about this space that we're operating in. One, this is a difficult bill. It's this is complicated stuff. Every now and then I pop up on the mic and say these are actually the spaces I think we are called to jump into because this is very difficult. There is clearly not universal understanding of what these mean or what it means to be, for example, God, a word I don't love in our spaces, but that's because we're not the same. We have different values. There is an important power differential that we really need to recognize when we are having these conversations. We are talking about autonomy versus the right of individuals to practice their religion. Both of those things I think are incredibly important. They are core values to who I am. And we are, by saying that an individual doctor's ability to express their values over the individual autonomous rights of a patient, we are making a choice there. And we are making a choice that many people will come down on many different sides. But one of the things that we need to recognize is that when you have a doctor in a medical system that has too few doctors, and one of those doctors makes a choice, that choice is then being made for everybody for whom that is the only available doctor. And this is not the only form of healthcare that we have done this for. If we exclude the right of individuals to access healthcare in the world in which they live, they have no other choices. And I don't know always what the right, I mean, we just heard reference to my healthcare, right? My healthcare is extremely important to me and life-saving. And the way that it is characterized by the other side is incredibly offensive to me. And it makes me so deeply sad for the people who need it and whose only healthcare options are people who will not provide it. Because it is not what you think it is. It is life-saving healthcare. And now we are talking about a different form of healthcare and whether or not it is healthcare, and we are having that debate. But we can't just assume that one person's right to express their religious values is always the right way for us to overcome the individual autonomy. We have to have that conversation. My religious values are not the same as your religious values, and one of them is not more important to be protected by the government. It's just not true. I have deeply held religious beliefs about what it means to live and what it means to die. And we have to recognize the power differential at play when we allow one individual's religious beliefs to govern an entire, sometimes county, of people's religious beliefs. So I just really want us to refuse this idea that this is somehow a simple yes or no, black or white issue. That's not what we're doing. We're having extremely complicated legal arguments about what it means to die. And we have heard, I want to thank the death doula who came to speak. That's some of the most important work I think that happens on earth, is people guiding people to their death. And the idea that we can just say, you're playing God, it's not just offensive to her work and all of our works, but it's a divisive statement that disregards the religious beliefs of so many people on earth. So just let's not pretend like this is easy, and let's not pretend like our side are monsters, because we're just trying to do what's best for people.
Representative Scott.
Thank you, Chair Becker-Finn. I want to just first acknowledge, I want to thank everybody that testified in person today and who sent in testimony. We had quite a lot of people that sent in very compelling, excuse me, and heart-wrenching testimony. But I do have a couple of questions and some statements. But first, I wanted to ask Dr.
And Representative Scott, we don't have time for a whole bunch of.
I just have one simple question for one doctor. If Dr. Stephen Bergeson could.
Representative Scott, is there a way to make your point without calling up?
No, I really
witnesses?
don't know the answer to the question that I'm going to ask, and I know a doctor will be able to answer that question. So, Madam Chair.
I don't know if this person is still here.
Yes, he is. And I'll go ahead, well, he probably needs to reintroduce himself, is that right?
Nope, just go ahead.
Okay.
I know there are other important bills. I know
Yep.
there are testifiers that
Yep, well,
travel to
this one
get.
is super important, Madam Chair.
Okay, well, there are testifiers. I know you said that you cared about the testifiers that traveled to get here, and I just want to make sure we have time. It's not, I don't typically allow a bunch of questions of
Thank you.
testifiers.
Dr. Bergeson, what's the penalty for a doctor to falsify a medical record? If you know.
Dr.
well-
Bergeson, if you could reintroduce yourself and then answer.
Yeah, Stephen C. Bergeson from Shoreview. That would put you at odds with the State Board of Medical Examiners, so that my licensing board probably would affect my employment.
Thank you. That was my
Representative
question,
Scott.
Madam Chair. That was my question to the doctor. Thank you. There's several concerns with this bill, but one of which is you're asking physicians to lie on a birth certificate or a death certificate. You're asking them to put down that in case of terminal illness, say cancer, that you're asking them to put cancer as the cause of death, when a lethal injection or a lethal dose of drugs is the actual cause of death. That's one of my problems with this. Representative Freiberg, I'm wondering why there's so little data in this bill that you're wanting to collect. What you're asking in this bill to collect is the number of prescriptions for lethal doses provided, the number of providers who provided lethal doses, the number of qualified individuals who died following the lethal dose per self-administration. That's all you're asking for. And so I'm just wondering why such a narrow set of data that you're asking to be collected.
Representative Freiberg.
Thank you, Madam Chair. You just listed off a few different things. To me, that seems like a fair amount, actually. And I know it's required that all reports be submitted within the first 4 years as well. If you have ideas for other things of data that you believe, other items of data that you believe would be helpful, I'd certainly be interested in hearing what those are. But in my mind, this is collecting the information that I think is most relevant.
Representative Scott.
Thank you, Madam Chair. Representative Freiberg, I believe this bill is patterned after the Oregon bill. Is that right?
Representative Freiberg.
Thank you, Madam Chair. Correct.
So,
Representative
thank you,
Scott.
Madam Chair. If you look at the Oregon bill or the Oregon law, they collect pages and pages and pages of data. So I'd be glad to work with you, but really all you have to do is look at the last Oregon report, and you'll see pages of data that they're collecting: ethnicity, age range, education level, marital status, county by county. It's literally about 5-6 pages of data. So I think that we need to collect more data on this. If this is to become law, we need to be able to have informed decisions going forward on this as to whether this is the right decision for the people of the state of Minnesota or not. And as you know, data will help guide us in those in that decision-making process. I just want to state something that was a theme of the testimony that was submitted online. And one of the themes there was that people way outlive sometimes their prognosis. I don't see this bill addressing, it seems like these prognoses are exact science, and we know that that's not true. People are given 6 months, live 2 or 3 or 4 or 10 years sometimes. So I feel like we're not giving voice to that fact. And Representative Freiberg, I really have concerns about this whole shortage of physicians in the state of Minnesota. And we've heard from physicians today that have a conscientious objection to this. And I think there's a differentiation between someone's conscience sometimes and their religious beliefs, Representative Fink. I don't think it's always those two go hand in hand. Physicians are taught in medical school, and at least I hope they still are, to abide by the Hippocratic Oath. That's do no harm. That's to be a healer. And so for some, and I think some of these folks, I don't want to put words in their mouth that testified today, it's a complete objection in their mind, their mindset between what's right and what's wrong. That doesn't necessarily have anything to do with their religious beliefs. In their mind, giving someone a tool to take their own life is against their conscience, against what they think is right and wrong. So your bill's not providing for that. You're basically making them sort of an accomplice by saying, well, I won't promote this way of dying, but here's a guy that, or another physician that will assist you. And so I have a real problem with that. And I particularly have a problem with that coming from the party that doesn't want people that go in for an abortion to be advised in another way, the options that they have for adoption, to see an ultrasound. They don't want any of that. But in this case, we have to tell a physician, yeah, if you're not willing to do that, you have to provide your patient with the name of someone that will. This is a horrible bill. It sets terrible precedent. We could go into what's happening in other states that have adopted such laws and how they're trying to expand them. California right now is trying to expand their physician-assisted suicide laws. This is just the wrong notion. We're creating a culture of death here, and I will oppose it. Thank you.
Closing comments, Representative Freiberg.
Thank you, Madam Chair. So, I mean, it's been an interesting discussion. I can only point to those same three provisions so many times that show that providers have no obligation to participate. You know, the provision, I think, that Representative Grossell referenced on starting on line 10.12, where he said there's the instance of must, but I think the whole context is important there. It says, and Chair Becker-Finn, you cited this, the whole paragraph reads, if a provider is unable or unwilling to fulfill an individual's request for medical aid in dying, medication, or to provide related information or services, we're suggesting they don't even have to provide the information, but which Representative Finke, I thought you made just an excellent point about that too. We don't necessarily want to be in the business of having people withhold information, but requested by the individual, the provider must, upon request, transfer the individual's care and medical records to a new provider consistent with federal and Minnesota law. So they just have to transfer the person to another provider. You know, physicians follow their ethical obligations that allow them to follow their conscience. They should not withhold information as an ethical obligation. They answer to their professional standards, but this bill does give them legal immunity if they choose to follow those practices. And I realize that may shut some people out as well from a medical procedure, Representative Finke, but you know, as you pointed out, it's a very tough balance here, and we don't always know what the correct answer is. Regarding the whole issue of prognosis, it's a good thing when people outlive their prognosis, and that does happen sometimes. However, the data from Oregon show that people who use medical aid in dying are primarily have two diseases, either certain types of cancer or ALS. Those follow very predictable paths, and the prognosis in the situations where medical aid in dying is likely to arise are somewhat predictable. So this bill is consistent with the autonomy that we've highlighted throughout this session. It's not an easy bill to talk about, but I think it's a really important one. I've heard very compelling stories from Minnesotans all over the state who either saw a loved one go through something they found unbearable or they're going through it themselves. And this bill just gives them another option. It doesn't require any provider to participate, and it doesn't require any patient to participate. So I do appreciate you giving this bill the time it deserves, and I hope you'll consider supporting it. Thank you.
Thank you. I will renew my motion that House File 1930 as amended be referred to the Commerce, Finance, and Policy Committee. A roll call having been requested, the clerk will take the roll.
Chair Becker-Finn.
Aye.
Vice Chair Frazier.
Aye.
Minority Lead Scott.
No.
Representative Carroll.
Aye.
Representative Curran.
Aye.
Representative Feist.
Aye.
Representative Finke.
Yes.
Representative Frederick.
Aye.
Representative Grossell.
No.
Representative Johnson.
No.
Representative Moeller.
Aye.
Representative Niska.
No.
Representative Weens.
No.
8 ayes, 5 nays.
All right, with 8 ayes and 5 nays, the motion prevails and the bill is on its way to Commerce. Thank you. House File 3389, Representative Pursell. I will move House File 3389 be placed on the general register. I understand we have an A1 amendment, and members of the audience, if you could try to be as quiet as possible so we can continue to work, that would be great. I understand there's also an A1 amendment. Would you like me to move the A1?
Yes, please, Madam Chair.
All right, I will move the A1 amendment. Do you want to tell us briefly what the A1 does?
Yes, thank you, Madam Chair. The A1 amendment clarifies that this provision only applies to agricultural land. There's a technical correction, there's a 5-month pushback date to implementation, and it just applies to private land.
Got it. Any discussion to the A1? All those in favor, please say aye. Aye. All right, the motion prevails. The bill is in the shape you would like. Representative Pursell, please tell us about your bill.
Thank you, Madam Chair. House File 3389 works to accomplish 2 things. The first, private buyers of agricultural land should know all the infrastructure on the land: wells, septic, and tile. And those of you not familiar so much with agriculture, the definition for what tile drainage is found on lines 1.6 through 1.8. Secondly, since the job of our soil and water conservation districts is to manage our soil and water, having a better understanding when subsurface hydrology is altered means better use of these professionals' time and our taxpayer dollars. Water knows no political boundaries, therefore a state entity needs to track these sometimes dramatic changes on private land, since there's great potential for that to have impacts to other landowners and communities downstream. I have been in conversation with county recorders, Minnesota realtors, MACO, Bowser, agricultural groups, and water management districts. I've committed to them I'll keep working collaboratively and in good faith to increase transparency in this important and largely unregulated area of agriculture. And I know there are some folks who are here to testify.
Yep, we've got one testifier showed up, Amber Bougie. Please introduce yourself and proceed with your testimony.
Good morning, Madam Chair and committee members. I'm Amber Bouget, the co-chair of the Minnesota County Recorders Association, and I'm also the county recorder for Hennepin County. The County Recorders Association opposes requiring county recorders to process drainage tile disclosures and appreciates the opportunity to share our concerns. House File 3389, similar to the well certification statute, prohibits county recorders from recording a deed or other conveyance document unless it includes a statement that the seller does not know of any drain title on the property or contains the required drain tile disclosure form and fees. The county recorders have been working with the Department of Health on streamlining and modernizing the well certification process. Actually, just yesterday, the House introduced House File 4825. That is the bill we've been working on. The recording requirements in this bill are a step back from the progress we're trying to make in modernizing and streamlining our processes. Requiring this additional disclosure will be another component that would increase document rejections, causing additional processing and delay in recording and transfer. Further, the recorder would be required to collect a fee and information just to transfer it to another entity. This leads to additional overhead processing, collections, and refunds and disbursements. Representatives of the Recorders Association had a very good discussion with Representative Pursell, and we look forward to continued discussions. Thank you.
All right, thank you for your testimony. Are there any other members of the public wishing to testify on this bill? All right, not seeing any. We'll move on to member discussion. Any discussion to the bill? Representative Scott.
Thank you, Chair Beckerfin. To the bill's author, how widespread are the concerns with this? Are we hearing from a lot of people, or is this just, a few people that are having concerns?
Representative Pursell.
I think, I'm not sure kind of which side of concern you are asking about, but I've worked extensively with the soil and water conservation districts over the course of my career, and as they try to manage public ditches, looking at increased flooding and such, there's often a level of surprise because there is no regulation and no documentation of when people do alter the subsurface hydrology and install drain tile. So this is an attempt to try to get ahead of that so that the water managers, whether it's a watershed district or an SWCD, are then able to know, oh, well, if there's an 8-inch tile coming out here, that might blow out a culvert down there. So if that answers your question.
Representative Scott.
Thank you, Madam Chair. I'm just really wondering, if, my understanding is that, and I don't know if it was you or someone else, but one person bought a property and found out that there was drain tile. They wouldn't have bought it if they'd known that. So I'm asking from a consumer point of view if you're hearing from a lot of consumers.
Representative Pursell.
I have not heard specifically from folks. I shared in the Environment Committee that when I was farming, I was just renting land, but even my friends who I was renting from had no idea that there was drain tile installed. Typically, that actually increases the value of the property because we have tiled a lot of our wetter lands. So just like having a well increases the value or a septic system, knowing the shape and age ideally of that infrastructure is helpful. But right now it's not required. So my friends, when they bought the property, the person they bought it from in Manhattan didn't know that, didn't disclose that to them because it was another farmer who had been renting it who did the tiling. So as I mentioned, this tries to do two things. One, just be very clear on the disclosure when agricultural property changes hands, and also to help the water managers to better do their job and therefore spend our taxpayer dollars more wisely.
I'm assuming by the way you said Manhattan, you mean New York.
I do, yes.
Thank you. Representative Scott. Had to make sure it wasn't Kansas. All right, seeing no further discussion to the bill, closing comments, Representative Pursell.
Thank you, Madam Chair. Thank you, committee, for hearing these provisions. I know it's a little bit niche, but it makes a really big difference in my community and lots of places in rural Minnesota. So I'm committed to continue working with the recorders, the Board of Water and Soil Resources, and other parties to make this more beneficial from this point going forward with transparency. Thank you.
Great. With that, I will renew my motion to recommend that House Bill 3389 as amended be placed on the general register. All those in favor, please say aye. Aye. Opposed? Motion prevails. Thank you, Representative Pursell. I can never see anybody behind those tall chairs. Representative Urdahl. I will move to refer House File 4101 to the Public Safety, Finance, and Policy Committee. And then I understand there is an A1 amendment. Representative Urdahl, would you like me to move the A1?
Yes, please.
All right, I will move the A1. Representative Urdahl, welcome to the committee. Can you tell us briefly what the A1 amendment does?
Thank you, Madam Chair and members. Concern was brought to me about address exposure. The Secretary of State's office brought this. This amendment addresses their concerns.
Great. Any discussion to the A1? All those in favor, please say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Representative Urdahl, please tell us about your bill as amended.
Thank you, Madam Chair, and I'm really going to shorten up my stuff here so I can get to my testifiers. Basically, what this bill does, the most important change in the bill involves adding the notice and service requirements to make sure that custodians of minor children are kept informed of all filings, hearings, and orders that affect the minor child under their custody. And so essentially that's what the bill does. I want to give an explanation of the impetus for bringing this bill before you. On March 24th, 2022, 13-year-old Isaac Hoff was stabbed to death while visiting his mother's Rihanna Heck's residence. His grandmother, Sandy Hoff, who is with me today, had full legal custody of Isaac. Rihanna had had a restraining order placed upon her boyfriend Houston Morris at the beginning of March. Within 2 weeks, she had the order removed. Isaac's grandmother was unaware that the order for protection had been removed when Isaac went to visit his mother. At her home, a violent incident broke out. Morris attacked Rihanna, who produced a knife to protect herself. Morris took the knife away and slashed Rihanna. Isaac sprang to his mother's aid. Morris attempted to stab Rihanna, but Isaac intervened and was stabbed in the chest. Isaac called 911, pleading for help for himself and his mother. With his dying words, he named Houston Morris as his assailant. Had his grandmother known about the removal of the restraining order, she would have told Isaac to stay home that night. The gist of the bill is to ensure that legal guardians providing care and support for minors are included in any updates to restraining orders. In his last words, Isaac cried out for justice. Let Isaac's voice be heard in this legislation. Now, we do have the transcript of the 911 call available. I did not have that put into your packets. Not going to read it, but I will tell you that I do have a copy of it. If any of you are interested in reading it, contact me and we'll give it to you. So with that, I have my testifier.
Right, thank you. And I do just want to clarify for the record, you use the word restraining order, and this is specific to orders for protection, which
yes.
is specific to domestic abuse
Right.
incidents. So just want to make sure we clarify
Okay.
that.
Thank you.
Welcome to the committee. Please introduce yourself and then go ahead with your testimony.
I'm Sandy Hoff. I'm Isaac's grandma and legal guardian. I had been all of his years, since he was the age of 2. Had I known about the restraining order, I only found out about the restraining order through Isaac. He's the one that told me the 1st of March that his mother had taken out a restraining order, and it was for her, him, and he had a little sister who was a year old, and me, because he lived over at my house, so my residence was included. And he told me that himself, and he was so happy about it, because he didn't like Houston, he didn't want to be there, he just didn't want to go there. So I'm not even so sure that he knew that the restraining order was lifted. And I only found out about the restraining order when I went to the hospital that morning that he was stabbed, and I asked Sheriff Habel, what about the restraining order? And he said that was lifted 2 weeks ago, he said. So she had the restraining order out. She took it the first part of March, and she took it out within 2 weeks, and then he was gone the end of March, the 22nd. I have Isaac with me. I have a picture of him on my shirt, so I know he's with me today. And I know he wants his voice to be heard, to try and protect other kids from the same situation, if possible. He would so want that, because he was a protector, not only of his mother, but his baby sister. And the only reason he was there was his mother was supposed to be going to treatment the following day, and he begged to go there to spend some time with her, I'm sorry. So I, of course, said, yeah, he could go, not knowing this was, I didn't know Houston was there. I wasn't aware of anything. You know, he just wanted a relationship with his mother, and I respected that. All the years I had him, I respected that he wanted a relationship. She was his mother, regardless of what she's done or what kind of life she had. So I did respect that through a lot of supervised visits and stuff, but it was just sad that he had to have his life taken in such a horrible way. And I would like the bill passed. That's why we're here, because I think, I just want to, I know he'd want to protect other kids, even if it'd be 1 or 2 in some way. I know that's what he would want.
We're very sorry for your loss, and thank you for traveling here to testify in person. It is important. We do have another person signed up to testify, Darla Byrie. You can wheel another chair over if you'd like, Representative Urdahl.
Thank you, Madam Chair. My name is Darla Byrie. I am Sandy's niece. I guess she pretty much said it all. If you guys took the time to, or would like to take the time to read the 911 transcript, I have read it. It's incredibly hard to read. None of us have listened to it because the Sheriff's Department has told us it's so horrible that this 13-year-old on his last dying breath made a 911 call that could have all been prevented had Sandy known that that restraining order was removed, because she would have not let him go there. He would have not been placed in that house that morning. And of course, he was a protector. He would have protected his mom as he did to his last breath. So we ask that you pass this.
Thank you for your testimony. Are there any other members of the public wishing to testify on this bill? Right. Not seeing any more, we'll move on to member discussion. Thank you both so much for your testimony. And again, we're very, very sorry. And I have read the transcript. I think Representative Urdahl did a good job of describing what happened. If folks don't feel like exposing themselves to that, it is a really hard transcript to read. But we thank you for bringing that up. Moving on to discussion, Representative Scott.
Thank you, Madam Chair. Thank you, Representative Urdahl, for bringing the bill, and thank you to the testifiers. It's hard to have to relive it, but I hope that this will give you some resolution and that Isaac's death is going to be able to help other people. And I want to assure you, grandmother, you did nothing wrong. You did whatever you thought was right, and always by allowing him to have that relationship with his mom, you had no way of knowing. And I'm really sorry that, for what happened. And I too read the transcript. I just have to say, what a brave young man. How courageous, and just to be proud of that. To have the presence of mind that he did, and that I just was amazed reading through it, that this was a 13-year-old young man. And so I hope that we can pass this bill for you and that it becomes law. Thank you, Madam Chair.
Closing comments, Representative Urdahl.
Thank you, Madam Chair. Just appreciate your hearing this bill, and, please move it forward. Thank you.
Yeah, and we have been in contact with the Public Safety Committee, and I think it's the chair's intention that we continue to move it forward in that committee as well. So with that, I will renew my motion to refer House File 4101 as amended to the Public Safety, Finance, and Policy Committee. All those in favor, please say aye. Aye. Opposed? Motion prevails. Thank you again for testifying.
Thank you.
Representative Urdahl. With that, we are adjourned.